Hello everyone, Steph here. For those who don't know me, I'm the CTSI Lead Officer for Animal Health and Welfare. Lovely to be with you today. In this virtual world, what I intend to take you through as part of the virtual symposium is a presentation in relation to dispelling the myth on animal welfare enforcement. So, for many of us, it's been one of those sort of areas as to is to may, is to must. And it certainly has been the subject for a debate for a number of colleagues for a few years now as to whether or not there is an obligation for local authorities to enforce the animal welfare rules or not. So the intention of the next couple of slides that I'm going to go through with you basically are going to look at, is it a may, is it a must, what does the legislation actually say, and sort of how do we apply it. I think one thing to add is that regardless of whether or not it is a statutory or non-statutory obligation with regard to animal welfare, ultimately at the end of the day, in relation to whether or not an organisation, a department, undertakes work relating to animal welfare, that's going to come down to, obviously priorities within that service. It may or may not be that animal welfare does factor as one of the priorities for the service in which you sit in. So, where are we going to start with this? It's quite a lot of unravelling to do, really. But I think in relation to the start of things, whilst I appreciate that we have taken the decision as a country to leave the European Union, regardless of what we think about it or not, we have to go back to the EU legislation, and in doing so, we need to look at sort of directives and regulations that come out of Europe, which apply to animal welfare. We are talking purely animal welfare in relation to today. With regards to animal health, it is quite clear under the Animal Health Act 81 that you have got a statutory obligation, or local authorities got a statutory obligation with regards to the enforcement of the Animal Health Act 81. Today we're talking about animal welfare. And so if we look at Regulation 2017-625, this is a new piece of law that's come in basically on the official controls and other official activities which are performed to ensure the application of food and feed law. And in addition to which, it's on the rules of animal health and animal welfare. It also includes plant health and plant protection products. But this piece of legislation from the EU, this regulation 2017-625 on the official controls, it came into force on the 14th of December last year, and it is directly applicable. So we don't need any domestic legislation in relation to the enforcement of this. So with regards to the UK, as I've mentioned, we don't need any domestic statute. It would be put onto the UK statute books, and we need to implement this regs without having to actually introduce domestic statute ourselves. As we are still a member at the point where this legislation was introduced back in December 2019, we were still a member of the European Union at that point. So it does become directly applicable to us. And even though we're going through the transition period at the present moment in time, it would still apply. The regulations themselves, it's part of a package of 3 separate pieces of legislation, one of which contains Regulation 2016-429, which is on the animal health legislation, which is the new animal health law. Another one is in relation to the plant health and plant products, which, obviously is not an area that we would necessarily be concerned about within the animal health world. But the Smarter Rules for Safer Food, it's a package which basically is going to modernise the legislation that we're working to. It's going to simplify and improve existing health and safety standards for the agri-food chain. The agri-food chain is probably one of the most complicated areas for enforcement with regards to trading standards. If you look at animal health and welfare, you're probably looking towards probably 200 pieces of legislation by the time you've taken the EU regulations, the primary acts and the secondary legislation that's been made under the acts for enforcement. So it's quite a complex area, and ultimately where we find some of the big hitters in relation to the impact of animal health and welfare on the UK economy. A number of these big impacts have been made in the agri-food chain world. So whether it be foot and mouth, whether it be BSE, whether it be the horse meat scandal, they have a major impact on consumer confidence and on the economy for the UK. So Regulation 2017-625, it is the legislation that's been brought in for the monitoring and enforcement of the agri-food chain. So we're talking basically from farm to fork, from stable to table. Now, how does 2017-625 apply to welfare? We've already said that the legislation governs animal health and welfare. Well, what it does, it amends a couple of key directives that have come out of Europe in recent years for the protection of animals. There is Directive 98/58, which is protection for animals kept for farming purposes. There is Council Directive 1999/74, which lays down minimum standards for protection of laying hens. We've got 2007/43, which lays down minimum rules for protection of chickens which are kept for meat production. We've also got 2008/119, which is the directive on the minimum standards for protection of calves. And then we've got 2008/120, which is the minimum standards for protection of pigs. So 2017-625 is amending some of these key welfare directives. So what's the amendment, we ask? Well, if we look at the legislation, what it says is that in relation to 2017-625, the amendment is in order to ensure consistency, the directive and whatever it may be in relation to calves, sheep, hens, meat, laying hens, hens kept or chickens kept for meat production, etc. It amends the directive to say that a competent authority means competent authority is defined in Article 3.3 of 2017-625. So we know that for the purposes of the directive in relation to the welfare of farmed animals, a competent authority is the person who is defined in Article 3.3 of Regulation 2017-625. So what does Article 3.3 say? Well, basically, that says that the competent authority is going to be the central authority of a member state that's responsible for the organisation of the official controls and or the other official activities in accordance with the regulation and the rules referred to in Article 1.2 of 2017-625. So this means realistically it's going to be central governments, Welsh governments, Scottish government, people who've got that central responsibility for the organisation of the official controls. It's also going to include any official agencies, bodies that come out of there. So, for instance, in England, we're looking at DEFRA, APHA, the Animal and Plant Health Agency, who govern controls for animal welfare across England, Scotland and Wales. So they've got a responsibility quite clearly. We then look at Part B in relation to competent authority. It says, and any other authority to which that responsibility has been conferred. So we then have to ask ourselves, within statute to local authorities, has this responsibility been conferred? Having had conversations with colleagues in DEFRA with regards the mirroring piece of legislation 2016-429 on the animal health laws, and in relation to other aspects with regards competent authority with the Food Standards Agency, etc., as the statutory enforcers for most of the animal health and welfare legislation across the UK, then I would suggest that yes, local authorities are deemed to be competent authority by virtue that the powers that have been passed them by the relevant governments of devolved nations to enforce animal health and welfare legislation. So, yeah, I'm quite happy. I feel that we sit as competent authority. So, if we look at the previous slide, it says in relation to the rules referred to in Article 1.2. Well, what does 1.2 cover within 2017-625? So what Article 1.2 covers, it's the scope of the legislation. So it's saying that the regulation is going to apply to the official controls that are going to be performed for verification of compliance with the rules, whether we've got those established at a union level or not, to apply the union legislation in the areas of, and then it lists a whole host of areas, including animal health, which we would expect. But then this is where the key element comes in, because it goes on about the welfare requirements for animals. So the legislation is saying, yeah, competent authority has to apply official controls for the verification of compliance with welfare requirements for animals. And when we look at the scope in Article 2.1, for the purpose of the regulation, official controls means any activities that are performed by the competent authority in order to verify compliance by the operators with the regulation and with Article 1.2. So for the purpose of the regulation, it means the verification checks that we're undertaking for compliance with the law, basically by those businesses that operate within the law, within the industry members. So taking that forward then, points for consideration, I would suggest that local authority with the responsibility for animal health and welfare enforcement on farm is going to be a competent authority within the scope of the law. I believe that the scope does include animal welfare, and that as part of that scope, the official controls includes the verification of compliance by officers. So we're going in to make sure that they are complying with the law as directed. So taking that a little bit further on now, I'm going to look at Article 21. And Article 21 actually then goes on and details the specific rules on the official controls and the action to be taken by competent authorities in relation to the welfare requirements for animals. And basically, what it says is the controls shall be performed at all relevant stages of production, processing and distribution across the agri-food chain. So this is on farm, this is livestock hauliers, through our livestock markets. These elements of 2017-625, actually we've got a duty to ensure that the rules and official controls are applied across the board through the agri-food chain. Now, when it comes to things like the welfare of animals in transport order or the welfare of animals in markets order, those two pieces of legislation are made under the Animal Health Act anyway, and therefore there is a statutory duty to enforce the Animal Health Act. So therefore, I think it's quite clear that things like welfare of animals at market and the welfare of animals in transport, we have to do those. So, and I think all this does now is it's made it clear that through 2017-625, actually, it isn't just those two areas where we'd got that statutory obligation previously. What they're saying now is, you know, you are a competent authority under the regs, and therefore there is a duty to perform at all relevant stages of production, processing and distribution. So my conclusion on that is that it's considered that as regulation 2017-625 is applicable, there is a statutory requirement for animal welfare, and it then does become a must, not a may. So I think that's quite clear under the 2017-625. To ensure that welfare requirements of animals are met as per Article 1.2 of regulation. But things are never clear. We then move on to domestic legislation. So our domestic legislation, we've got a couple of key pieces in place. Primary legislation for England and Wales, we've got the Animal Welfare Act 2006. Primary legislation in Scotland is the Animal Health and Welfare Act 2006. And then alongside of that, we've got a couple of regulations, all of which are pretty similar in content and run parallel across England, Scotland and Wales, and that's Welfare of Farmed Animals Regulations 2007. And the Welfare of Farmed Animals Regulations basically implement the directives on animal welfare that we spoke about at the very start of the presentation, which are those directives from Europe on calves, on laying hens, on meat hens, on pigs, farmed animals, etc. So these are implementing the directives that have come from Europe with regards to protection of animal welfare. So the Animal Welfare Act 2006, it is applicable to England and Wales. And what section 51 of that act says is that the appropriate national authority, so that's going to be DEFRA or Welsh Government, in reality it's going to come down to their agency from the Animal Plant Health Agency, and the local authorities, we may appoint inspectors. So it doesn't say we have to appoint inspectors, it's a may appoint inspectors. So we don't actually have any statutory obligation on a local authority to appoint inspectors. It is a domestic primary piece of legislation. It's not been brought onto the statute books as a result of EU law. What I would say in relation to the Animal Welfare Act is it is a really good tool to have in your armoury for enforcement. And I would certainly advocate that if officers aren't appointed under the Animal Welfare Act 2006, then they should be, because the powers that are available within the Animal Welfare Act far exceed those that you've got in any other legislation. So a really good piece of law to be working with. Scotland, similar provisions again. In relation to the provisions to England and Wales, this time section 49, you can be appointed as inspector by a local authority for the purposes of the provision, but there is no obligation on a local authority to appoint inspectors to Part 2 of the Act, as it's, again, domestic legislation for animal welfare and not as a result of the EU law. Scotland is slightly different. You'll notice in the title of the legislation, it is the Animal Health and Welfare Act 2006. So it is split into two parts, and it's Part 2 that deals with the welfare. So there isn't an obligation on the Scottish authorities either to appoint inspectors. But again, similar to England and Wales, some really good tools there, you know, to have in your armoury for dealing with matters where there is welfare. So that's the primary legislation. Look at the welfare farmed animals regs now, and you'll note that I've split this now into England and Wales, and then we'll look at Scotland separately, because there is just a subtle difference here. The regulations are made under the Animal Welfare Act 2006, and they apply to all animals that are kept for farming purposes. The offences are self-contained within the regulations. They're not part of the Animal Welfare Act, they are self-contained in the regulations. And the one thing that I'd advise you in relation to that is that because they are not under the Animal Welfare Act, be mindful of time limits. There is case law which was established through Sheraton Sigley versus Staffordshire County Council. And that does state quite clearly that time limits are 6 months. It implements the EU directives, which are governed by 2017-625. So it's going to implement those EU directives we spoke about earlier. And I think, therefore, when you consider the obligations that we've got with 2017-625 and who the competent authority is, and the requirements for animal welfare and the official controls and the verification of the official controls compliance by the operators, I think then for England and Wales, this piece of legislation, because it's silent in relation to who the competent authority is, it becomes a must, because we are the enforcers of the legislation, and therefore it's an obligation on the local authority, as competent authority isn't defined. And as I'd say, this is purely England and Wales. So the other aspect to this is there is no obligation, however, on a local authority to take a prosecution against anyone in breach of the law. So what the Welfare Farmed Animals in Wales says is that in their amendment legislation, a local authority may prosecute proceedings for offence under these regulations. And similar to England, that Welfare of Farmed Animals England regs is that a local authority may prosecute proceedings under the regs. So I would suggest that you are, for the purposes of enforcement of the regs, competent authority. However, you may prosecute. It doesn't say that you have to prosecute. I think the difference that we have between the English and Welsh and the Scottish legislation is that whilst it doesn't actually specify in the English and Welsh legislation who the competent authority are, the Scottish, in Regulation 10 of the Welfare Farmed Animals Scotland regulations, it does actually state who the competent authority are for purposes of the regs. And it states that the Scottish ministers are the competent authority for the purposes of and it goes on about Directive 98/58 on the animals kept for farm purposes, 1999 74 for protection of laying hens, 2007 over 43 over chickens kept for meat production, 2008 119 on the protection of calves, and 2008 120 on the protection of pigs. So it's quite clear in Scotland that the competent authority for the purposes of those directives are actually going to be Scottish ministers, which then would bring the responsibility down at the local level to the Animal and Plant Health Agency. What Regulation 12 of the Welfare Farmed Animals Scotland regs continues to say is that the Scottish ministers or the local authority may appoint inspectors for the purposes of enforcing the regs. So again, they don't have to appoint inspectors for the purposes of the regs. It's a may, not a must. Clear as mud. You know, back to the original in question, the enforcement of animal welfare rules, is it a may or is it a must? So my conclusions on it basically are that Regulation 2017/625, it is directly applicable and has been since 14th of December 2019. The regulation does govern all aspects of the agri-food chain, including the animal welfare. Local authorities are a competent authority. Therefore, we must ensure that we comply with the regulation for the official controls, which includes verification of compliance by the operators, as mentioned in Article 2. Domestic legislation, however, whilst the 2017/625 is a must, domestic legislation for the primary legislation of the Animal Welfare Act and the Animal Health and Welfare Act Scotland is a may. So there's no obligation on a local authority to appoint inspectors under that act. However, as I've said, it is a really useful piece of legislation and certainly would assist in the enforcement of the obligations under 2017/625. The competent authority for the welfare of farmed animals regulations for England and Wales isn't defined. As such, I would suggest that in consideration of this and in accordance with the provisions of the EU directives and 2017/625, local authorities are included as competent authority, and the enforcement of the regulations in England and Wales is a must. In addition to which, they may then take a prosecution for non-compliance with the regs. So it is a must that they enforcement is my take on it as part of the competent authority, but it's a may with regards to prosecution. And the competent authority for the welfare of farmed animals regs in Scotland is defined quite clearly that it's a responsibility of the Scottish ministers, but local authorities may appoint inspectors for the purposes of regulation, and as such there is no statutory obligation to appoint inspectors in relation to Scotland. So what the reality is, as I've said, it's always up to a local authority as to where they prioritise their resource within a service, regardless of whether or not it's a statutory requirement or not. And I would add that welfare is often indicative of animal disease, and therefore we should prioritise accordingly. So, dispelling the myth on animal welfare, I hope that's assisted you and busted any myth in relation to whether we do or whether we don't, or it may have just confused you even further. So thank you very much for that, and enjoy the rest of the virtual symposium.